Good morning. We see the sign-ins have slowed down a little bit. I'm sure we're going to get some more as we go forward in the morning. My name is Jeff Solomon. I do some work here with Gray Systems, a fantastic education resource for all of our CAMs and industry professionals. Welcome. This is our first Zoom. This is our Zoom debut of Fred's Roundtable lunchtime discussions. We're going to talk about whatever is on your minds today. Fred, I'm going to kick it back to you to please go over your advertised, what you mentioned you're going to go over about communications during the emergency powers and board meetings and such. So I'm going to kick it back to you to get started.
And welcome again. Let me say, I mentioned this whole discussion is built around questions that we received, large numbers of these questions over the past few months about conducting business during the COVID crisis. And I'm going to share my screen here with you, give you kind of an agenda of what we're going to be talking about today. And you should be able to see me and the screen here.
We see it.
We're going to, first of all, talk about the current state of emergency, also examine the board's emergency powers that we're allowed to take advantage of during the time of a state of emergency, briefly discuss that. Also, the potential for extending the state of emergency and what that does to you. Then we're going to go to discussing how we hold membership meetings in this time. I know many of you are moving into the time for your annual membership meetings. We have tons of questions about how do we do this, so we'll talk about that for a few moments as well. Then we're going to talk about board meetings, and how we handle those. And then we're going to talk briefly about the election process with the election of directors coming up. Then we're going to have the open session, address any questions that you may have, and as best as I can, if we don't know the answer, we'll try to find it for you and get that for you as well. So that's kind of where we're going to go today. I want to move on to the current state of emergency. As you're probably aware, the governor has issued state of emergency. I think we're on our fourth one now, 60 days each. This one was issued on November 3rd of 2020 for 60 days, as long as he can go at one time. This is scheduled to expire probably January 3rd or 4th, however the days work out, if he does not extend it. Under the state of emergency, we have the board's emergency powers, which I'm going to talk about in a moment. I will mention there has been discussion about extending the state of emergency as we see the COVID issue continuing on. So stay tuned, and we will alert you if the emergency is extended. State of emergency is extended as well. Under the state of emergency, the Association of Emergency Powers kick in. And I'm going to briefly read a section from the statute. It's in all three statutes, condo, co-op, and HOA. Most of this was directed at the after effects of a hurricane. Natural disaster, but since they had this in the law, they invoked this. The Department of Business and Professional Regulation back in March said this applied as well, but it says to the extent allowed by the law and unless specifically prohibited by the declaration of condominium, the articles or the bylaws of an association, and consistent with the provisions of the Board of Administration in response to damage caused by an event for which a state of emergency is declared in the locale in which the association is located, may, but is not required to exercise the following powers. And I emphasize the word damage there. That's what's in the law. That was referring to the hurricane damage, but the department says that COVID has caused damage as well, so this would kick in. And it does provide that we can conduct board meetings and membership meetings with notice given as is practicable. The law goes on and defines practicable as by any means that available to us as well. We can also cancel and reschedule any association meetings. I've talked with a number of associations that were scheduled to hold meetings in November, December, early January, and they have elected to either cancel those meetings or reschedule them into later times in 2021, which is obviously under the emergency powers is okay. We can also name as assistant officers persons who are not directors, which assistant officers shall have the same authority as the executive officers to whom they are assistants during the state of emergency to accommodate the incapacity or unavailability of any officer of the association. That's the language from the statute. It's the same language in all three statutes, condominium, cooperative, and HOA. So the board, to whatever extent that it can make decisions, has a little bit of latitude with regard to handling both membership meetings and board meetings, because it says cancel and reschedule any association meeting as well. Then we go to the meetings themselves.
Fred, and I want to just interject one thing real quickly too. We just want to remind everybody that you and I are not attorneys. This is informational, and if there's anything that you're unsure of with regards to anything you hear today during our discussion, it is best, if you're not sure, if you're unsure, to contact your association attorney. Correct?
That's correct. And thank you for saying that, Jeff. Should have said that earlier. This is education, we always say in our classes, but
yes,
we do like to kind of refer this back to the attorneys for clarification and implementation. Now, to talk about membership meetings, the corporate statute requires all corporations to hold a meeting each year as well. All three of the community association laws, condominium, cooperative, and HOAs, say that the association will have an annual meeting each year as well. It does not say when. That all defers to the bylaws, documents of the community, or policies put in place by the board if the documents don't allow such language. There's one thing interesting to note here. There are no provisions in the community association statutes for virtual meetings. The corporate statute does provide language that does accommodate virtual meetings, and 617.0721, which is the Not-for-Profit Corporate Act, and most of our community associations are organized under this law. There is a provision in there that says, if authorized by the board of directors and subject to such guidelines and procedures as the board of directors may adopt, members and proxy holders who are not physically present at a meeting may, by means of remote communication. And it goes on to say, attend the meeting, vote, participate, and all of that at the meeting. The important part of this paragraph is it says, if authorized by the board of directors. That basically means, based on what I've heard the attorneys talking about, that you will need to have a board resolution authorizing, if you so desire, what we would call virtual meetings. Meetings via Zoom, such as we're doing here, or the other platforms that are available out there as well. That resolution should be basically determined by, provided to you by your attorney, to make sure that you comply with both the corporate law and the provisions of the community association statutes as well. But you should, if you plan to hold virtual membership meetings, you would need that resolution adopted by the board. Other considerations with membership meetings, and we've talked with some people about this in the past, over the past few weeks as well. Some associations have decided to hold their, quote, membership meetings outside and on the grounds of the community and provide adequate spacing for the people who want to attend. The bigger problem people are running into is how do we accommodate those people who want to participate, but they don't want to physically attend because of their concerns about the COVID virus as well. There's not any provisions for that. There are no provisions for phoning in or anything like that. The only way you can participate outside of being there physically is through a proxy. I know some associations have facilitated that and allowed them to dial in, if you want to call it that, in some cases. But one of the problems with that is that doesn't necessarily mean that that person counts toward a quorum because they're not physically present, nor if we don't have a proxy, they're not present at the meeting either. So there's some complications there as well. But again, if you go back and have the resolution adopted by the board to allow virtual meetings, in that resolution, you can also basically lay out the guidelines for members to attend and to participate at the membership meetings as well. So that's kind of some thoughts about membership meetings. You need to be creative, whatever you might do. One big question we ran into recently was one association decided they were going to cancel their annual meeting, primarily based on the board's concerns, but also a large amount of feedback they got from the members who did not want to participate in a membership meeting at this time and were uncertain about when they would want to. So they decided just to cancel the 2020 annual meeting, hold it next year, 2021. Then the question came up with the question about what about the board? And we'll talk more about the board and the election in a moment. But basically, the corporate statute says the board members serve until replaced. So if we don't have a meeting to have an election, the sitting board remains in place. And then whenever we have a new election, then those people would be replaced according to the results of those elections as well. There are some problems with that when you have staggered terms, and you have to address that. How do you fill those staggered terms when you have that meeting as well? Those can be issues, and some of those things you want to basically discuss with your legal counsel and addressing that. And I know there's a lot of complications out there. I will mention one thing some people are not aware of. We have been operating in the condominium world for several years now, where they said if your documents allow 2-year terms, board members can serve 2 years. Last year or the year before, I can't remember which, the Condominium Act was amended to provide that the board members may serve longer than 1 year. And there's no upper limit now where it was 2 years. A lot of associations that had 3-year terms in their bylaws have reverted back to that as well. That can complicate the situation if you skip an election as well. So you have to plan for that when you do have your election and put that into the block pot as well.
Hey, Fred, let me interject really quickly. We have somebody raising her hand, and if it's related to what you're speaking about now, you want to check and see if it is, and if not, we'll move on.
No, sure.
Hang on. So Adriana, I'm about to open your mic. Adriana, can you unmute yourself?
Okay, I didn't know how to unmute. Okay, sorry. My question is, what about participation? The people that don't have access to internet, a lot of elderly don't. So,
thank you.
Again, and Adriana, and hello, by the way. That's been a discussion that we've had with a lot of people as well. If they want to participate, I'm talking about at membership meetings now. In any case, the members are allowed to attend membership meetings. But as I said, the condominium cooperative HOA statutes do not anticipate virtual meetings. Again, the corporate statute would allow that, excuse me. And I presume you could do something by telephone if you so desired. The way the corporate statute basically reads is that you can allow people to participate by any means of communication, which would include telephone, if they want to have a call in, if you want to provide a number where they can call in and participate by phone, that would be certainly available. The problem then comes with the voting. And can they vote by phone or not? The way the law is written, they either vote in person or by proxy. But if they're not physically there, does that count as in person? And I'm not making that up. I heard that discussion amongst several lawyers the other day, trying to figure out what in person means. That's like it has to be in writing. Does email substitute for in writing as well? Those are things you're going to have to address with your counsel or have the board say, this is what we're going to do. Many times what we do is we make a decision to try to accommodate everybody to the best of our ability, do what is best, and if it doesn't work out, see what happens with those people who object to it. I'm not saying do anything wrong, but we have to do what's best, particularly if we remain in a state of emergency. The way the law is written in the board's emergency powers in the state of emergency, the board is given wide latitude in how to handle these situations. The main thing of keeping in mind is we want to be able to conduct the affairs of the association so that it benefits everybody. Everybody has the right to participate. They have the right to exercise the right to vote and to accommodate all of that as well. So for those people that don't have the technology, we can work around that, like I said, with other communication standards, telephones, things like that as well. And I do know people that don't have access to computers, internet, or anything like that. I'm amazed at that in today's world, but it's not just elderly people. There's others out there as well that have basically said, I'm not going to do that, but that's an ongoing problem as well.
Okay. Okay. And we have thank you, Adriana. Is there anything else?
No, not about this. Okay. Thank you.
Thank you very much. And Fred, there's since there are no other hands raised at this point. There are two other questions related that were written into what you spoke about. The first one from Laura: what happens if the person is out of the country and due to COVID, they cannot come back on time, and they email their vote and proxy to be able to participate? Can they do that?
The corporate statute, the question relates to an electronic communication of a proxy to the corporation. The corporate statute does accommodate the electronic proxy. If you have a person who can't attend in person or who still so desires, if they make a copy of their proxy and either email it, fax it, or by other means provide it to the association, you can accept that proxy and utilize that at that meeting as that person being present. Also, if it's an HOA, the proxy, whoever's named as proxy, can cast the vote for that person who's not present. Obviously, if it's a condominium or a cooperative, if you're going to participate by proxy, almost all votes require the use of a limited proxy. So the association should provide that proxy form to all the owners in proper format. There's a proxy form that's been promulgated by the division for limited proxy use, where you have limited powers and general powers. And on the limited powers, you list all the issues that are expected to come up at that meeting, and then the proxy giver will indicate how they want the proxy to vote for them. And we must use a limited proxy when voting to waive or reduce reserves, when voting to change the financial reporting requirements, when voting to amend the documents, or when voting on any other matter for which the statutes require a vote of the membership. So we must use limited proxies in those questions, those issues as well. So that, again, electronic proxy is allowed under the corporate statute. It is not addressed in any of the community association statutes, condominium, cooperative, or HOA. But I presume since most of us are operating in 617s, that language is also in 607 if you happen to be a for-profit corporation as well. But again, we're doing whatever we can to accommodate the needs and desires of everybody in the association.
Right.
We're going to run into those issues across the board.
Right. Let's do, before you move on, can we do two more questions, then we'll move on?
Sure.
Okay. Cheryl asks, and this relates to when you spoke about canceling meetings with emergency powers if necessary. Cheryl says, well, some docs have specific dates in their bylaws. What then?
That's a good question. If your bylaws have a specific date that the membership meeting will be held, under the board's emergency powers, I think you can ignore that. And you would cancel that meeting and say, we're going to do it next year as well. Now, a lot of that depends on whether the state of emergency is extended. Right now, there's been no mention. There's a lot of speculation out there that the state of emergency will be extended for an additional 60 days at least. If that does happen, that's going to pretty much cover the annual meeting time through the first of the year. And we may have some issues there as well. But in my opinion, if the board feels that it needs to do so, they can just can't cancel the meeting altogether, even though it has a specific date in the bylaws. Okay. Otherwise, you may want to try to arrange a virtual meeting using a board resolution to authorize that, then arrange for a virtual meeting either by Zoom or some other platform or by phone or whatever type of communication it might be. As I said, 617-0721 does provide that authority, gives the board the authority to authorize that. They have to adopt a resolution and spell out how participation would take place as well.
Okay, this is good stuff, Fred, and we do want to emphasize that it is very, very important to use experienced association attorneys and using attorneys. And what we are doing here is not legal advice. This is just informational and educational. We have one hand raised. This is the last question we're going to take, so Fred can move on, and then we'll get to more questions going forward, I promise, including those in the queue if we have time. So Judith, I'm going to enable your mic. And then after Judith's question, pardon my tongue twister there, we will move on to the next slide. So Judith, it's related to what we're talking about now. Please go ahead.
Okay, thank you. Just wanted, can you hear me now?
Yes.
Yes.
Okay, great, thanks. I was about our budget. We vote on a budget at our annual meeting, which is coming up in January. And I just wanted to know, I know we mail out a packet, the proxies and everything in there. Should that be included, or do you have any advice with handling the approval of a budget at the annual meeting?
Judith, the only question I have is, do your documents require that the membership vote on the annual budget? Sometimes the board is empowered to adopt the budget. Then as a courtesy, they present it to the members at the membership meeting and let them, for lack of a better term, ratify it. Then it really does not affect the process. If, however, your documents, probably the bylaws, require membership approval of the budget, then you would try to get that approval by some electronic means, either proxies or holding a virtual meeting based again on a resolution adopted by the board, and do it that way as well. In the event that you can't adopt the budget, the way the law is written, the budget remains in effect until you get the new one. So your old budget would continue until you could get the processes together to adopt a new budget. That's probably the process that I would rely on there as well. Is that
Fred, which is, if I may interject, you can't email your vote for boards of directors, correct? You cannot do that.
No.
Okay.
Because that's in the for condominiums and cooperatives. We can talk about that in a moment. We have the process that we go through, which is balloting. You can mail your ballot in the ballot envelope, return envelope, and all that, or you can drop it off at the association. In condominiums and cooperatives, the election process is separate from the meeting itself. So that's different. But as far as HOAs are concerned, the voting is either by person or by proxy. Again, the budget could be approved if it does require a membership vote. The budget could be approved using the limited proxy form. If it's a condominium, if it's an HOA, then you can use a general proxy form to vote on the budget as well.
Judith, was there anything else?
I think that's it. Thank you.
You're most welcome. Fred, go ahead. Back to you, sir.
Okay. I want to move on. I might come back to any of this in a moment. I want to cover everything that I've had on my agenda today. I want to talk briefly about board meetings. I know many associations that I've talked to over the past few months have basically switched their programs to virtual meetings, but there is a provision in all three laws now that says a board or committee member's participation in a meeting via telephone, real-time video conferencing, or similar real-time electronic or video communication counts toward a quorum, and such member may vote as if physically present. A speaker must be used for the conversation of each member, may be heard by the board or committee members attending in person, as well as by any unit owners present at the meeting. Now, the big problem with the virtual meetings and the board meetings is how do we allow the owners, non-board members, to attend that virtual meeting? Obviously, we could open it up to have virtual attendance by everyone. That can be an additional expense to the association. There's cost involved in these virtual platforms. There's a limit on how many people you can have in one place and many times as well. But whoever is organizing the meetings has to keep that in mind. But under the board, all three statutes, condominium, cooperative, and HOA, the owners are allowed to attend board meetings and to participate. And participation is basically the right to speak. And the right to speak is with regard to all items on the agenda for that meeting. The bigger question comes, if they were going to allow the owners to speak, when do they speak? All the statutes allow the association to require a sign up if you want to speak or something like that. There are three basic ways you can allow people to speak at the meeting. You can allow them to speak, all those who've signed up, before the board considers any topics. To me, that's not the best way to do it. I think the best way to do it is allow the people who want to speak with regard to each item to speak before the board considers that item. The chair can bring it up to the board. The board then says, do we have any comments? Take the comments, and then the board has this discussion and votes on that issue as well. The least likely least desired method of allowing people to participate is to allow them to speak after the board's made all the decisions. Obviously, that's a moot point. They've already made the decision. Whatever the people say is not going to affect the decision at that point in time as well. So that's participation. The bigger question is, how do we allow them to participate? Are we going to do it by phone call? Are we going to do it by virtual meetings such as this? Then you've got to control that participation, much like Jeff is controlling our meeting here. You're going to do it as a webinar. You're going to do it as a meeting. Then you can control when they speak, who speaks. Also, it's kind of nice with this platform. If somebody gets a little bit out of control or out of hand, it's real easy to click that mute button on the microphone, where it's much more difficult to kick them out of the board meeting.
Did you say you wanted me to mute you?
Yeah.
No, just
But anyway, those are things to consider as well. I've recommended to all the associations that I've dealt with and talked with that they've got the statute, they've got all that. They've had the processes for conducting live meetings. I've always advocated that the board should have a board resolution spelling out how the board meeting is going to be conducted, how the members are going to be allowed to participate, time they're going to be allowed to participate. The standard is no more than 3 minutes per comment, and only one comment per person until everybody else has spoke on all those things. But have all that laid out, have it adopted as a rule or resolution by the board, and have that published for each meeting. Everybody knows what the rules are. Some people object to that. They say, well, it offends the owners to realize when I do that and say they can't speak for more than 3 minutes. Well, if you don't control it, it can get out of hand very quickly. We do know we have those people who like to dominate and control the meetings as well. But as far as board meetings are concerned, the virtual meetings are accommodated in statute. The bigger issue that we have to face is how do we get the members or provide the owners the opportunity to attend the meetings, and then address how the owners are allowed to participate at the board meetings. And we've seen this happening for the last 9 months now, whatever period of time it's been. And most of them have worked pretty quickly, or fairly well. One comment I've heard from many associations that I've talked to is that they find the virtual board meetings are much more efficient than in-person meetings. People who tend not to get distracted or get off on tangents or other things like that as well. And everybody seems to want to take care of business and get off the computer or whatever it might be. And I know a lot of associations have decided, even when the COVID issue, if it ever does goes away, we're still going to do board meetings this way. And because of the efficiency. Also, if you have people who have to travel, absentee owners, that kind of stuff like that, it makes it much easier for them to attend as well. So that's comments I have about board meetings, and I'd be happy to entertain any comments or questions you might have.
Yeah, we have somebody raising their hand with regards to what you spoke about just recently here. So John, I'm going to enable your mic, and if it's related to what Fred is discussing now or has discussed, the floor is yours. John, are you there?
Yes, thank you very much. Fred, this has been a bone of contention for me because our board president he lets the owners participate at the end of the meeting. He asks their questions and answers their questions. And I agree with you that before we vote as a board, that they should let the owners have their say. Is there something in the Roberts rules for meetings that the owners really should speak before the board decides on a particular topic or on the agenda item? Thank you.
John, that's an excellent question. I agree with you, but no, there's nothing in Robert's Rules of Order. And I'll mention something briefly here as well. And I'm trying not to step on anybody's toes here, but the president should not make that decision. That should be a board decision. The board should establish by resolution or rule the ground rules for conducting the board meeting. I personally think it should be a board vote on how we're going to do this. Robert's Rules of Order also does not address that because Robert's Rules of Order does not presume that the non-board members are going to participate. That's unique to community associations. We have the open meeting provisions of all of our laws, condominium, cooperative, HOA, where the owners have a statutory right to attend and to participate or speak. That's not common in other types of boards or anything like that as well. So that's kind of unique, and that's not really anticipated in Robert's Rules of Order in that regard as well. But I agree with what you're saying. If we're going to allow the owners to participate, it should be before the items are considered by the board. Even though it may not have any effect on the board's decision, it allows them to say, okay, they let me speak and I said my piece, and they've elected to go in a different direction. But I feel that's more effective communication. I think it fits better with the members of the community, makes them feel better that if there's somebody's listening, whether they're hearing it or not, it's a different story. But again, to me, that's the most courteous way to do it. And unfortunately, there is nothing in writing that says that that's the best way to do it, that we have to do it that way.
I'll try and persuade the board president with my colleagues to change the rules to let the members partake in before we vote. Thank you very much.
I'm sorry, did you say something, John? Okay.
He thanked us and he signed off.
Okay.
There's a couple of questions in the queue before you get to the next slide. What about the actual election? Can this be done through virtual means?
Well, hold that question for just a second, Jeff. I'm going to go to elections.
All right, then I'll leave that one. Margaret had a question. Am I correct in understanding that associations were allowed to not hold meetings at all this year in any format due to COVID-19? Is that how the emergency powers works?
Yes. In my discussions with my legal friends, the way the board's emergency power language is written.
And it's best too, if you do have, Fred's going to answer this question, but it is best to consult your association counsel about this. But
Yes,
Fred, go ahead.
Definitely. But the way the statute's written, it says the board can cancel all meetings, cancel or reschedule any meeting. So if they don't want to have meetings altogether, that's perfectly okay. I find that to be a little bit of a concern, though, if there are things that have to be done by the board. The board cannot make a decision as a board outside of a meeting. We've had situations where the board does things by consensus. There was provision put into all three of our community association statutes that prohibit board members from voting by email. It was quite common in earlier years for the board members to convene by email, and they'd email each other and say, well, we all agree on this, let's do it. And then they give an edict to the manager. We voted on it, we'll ratify it at the next board meeting. Well, technically that's not open meeting provision of the law, so that the board can't function that way. So I think we need to do something to accommodate the board's ability to make decisions as a board. Also, as I said a moment ago, with certain exceptions, obviously, the individual board members can't make decisions. The board makes collective decisions, and they only make those decisions by meeting, discussing the issues, and voting. So those are the problems with the board participation. But I think, I don't know if that answers the question or not, but that's kind of where we'll come from there.
And then one more, there are a couple of questions in the queue that are elections related that you mentioned we'll hold off on. But this last question here, and this will be the last one, then we're going to go to the next slide. Are there any limitations with regards to the size of an association, meaning the amount of units necessary in order to conduct this type of video meeting, or does it apply at all? I think I know the answer to that. I don't think the size of the association matters. You can have virtual meetings no matter what, correct?
Correct. There's no limit on the size of a virtual meeting. The issue becomes, do you have—
Or association size, no limit on the size of the association. It could be 5 units, or it could be 5,000 units, correct?
Correct. That's correct. The issue becomes a quorum. In a membership meeting, you cannot conduct any business unless you have a quorum in attendance. The question about is in attendance. What does that mean? Is that in person or virtually? Obviously, if you provide a proxy to someone to act for you, then you are in attendance by proxy. So that's the issue. Can you have a quorum that you have? There's also some questions we get about how many people can gather in one location. Right now, under stage 3 of Governor DeSantis' open Florida order, there's no limit on how many people can be in one room. Associations, however, boards can adopt resolutions for the welfare of the community to limit the number of people that may be allowed in one facility. Whereas you may have a clubhouse or something like that where you traditionally have your membership meetings, and it's only a certain size. And in that size, you can't provide what we're referring to as social distancing in that meeting. And those are times when you may want to move that meeting somewhere else. You may want to go outside, arrange that as well. I think the bigger issue is, in order to conduct business at a meeting, you have to have a quorum present, except for the election in condominiums and cooperatives, which we're going to talk about next. So there's no limit on the size of any size association can conduct virtual meetings based on their ability to do so.
Excellent. Okay, let's go on.
I want to talk briefly about the election process. We got a lot of questions about this. Fortunately for condominiums and cooperatives, the problem for the election of directors is basically solved automatically. We have a process for electing the directors in the condominium statute, the cooperative statute, also the Florida Administrative Code that spell out the procedures for conducting the election. That's the 60-day first notice of election, the 40-day cutoff for anyone who wants to be a candidate for the board. We have the candidate information sheet provision in there as well. And then we provide, if we have more candidates than vacancies, the best thing can happen is you have the same number of candidates as you have vacancies, in which case no election is required. If you have more candidates than you have vacancies, then we have the balloting process. We provide each owner with a ballot. The ballot must be sterile. All the candidates in alphabetical order, surname, no recommendations from the board or anything like that. Then you have the ballot envelope, which you place the ballot into. You have the return envelope, which you place the ballot envelope into. Return envelope has space for the signature of the owner and the unit number. If that's not filled in, that ballot's not counted as well. All that's provided back to the association, either by mail or by hand delivery, whatever. We can do that as well. I will make a comment. There is no provision so far that allows that to be done electronically. Email, scan and email, et cetera, like that, because of the balloting process, the secret balloting process. Now, many of you have elected to use the electronic voting procedures outlined in the statute. That works perfectly well for the election as well. Also, the election is not related to the meeting. You can have an election without having a quorum or actually holding a physical membership meeting. All that's required is that you have ballots cast by at least 20% of the eligible voters to have a valid election in a condominium or cooperative. So that process in condominiums and cooperatives is pretty well accommodated. We can do it not virtually, but in absentia, where you don't have to attend a meeting in the first place. So that's good for condominiums and cooperatives. It's a little more problematic for homeowners associations. Most homeowner association documents provide that you vote in person or by proxy. Obviously, if you don't have a meeting or for the purpose of conducting the election, then your board's going to remain in place. If you do try to hold a membership meeting to conduct the election, then there's a catchphrase in the HOA statute that says if you have the same number of candidates or fewer candidates and you have vacancies and you don't have a quorum, then those people automatically take office. So you don't really have to have an election in that case as well. But you do have to examine your HOA documents to determine how you're going to accommodate proxies in the election process. There is no procedure in the HOA statute or for secret balloting. Having said that, however, I know a lot of HOAs where the board unilaterally has adopted the condominium balloting process. I'm not sure that's valid. You want to verify that with your association counsel. I know some associations have basically amended their bylaws to provide the condominium election process. If you have amended your bylaws, and obviously that was done with council's consent, not consent, but consultation. So I'm sure that you can do it that way as well. But the board is not empowered to go out and make that decision on its own. So you have to go back to your documents to figure out how you're going to conduct the election. You try to work it around to accommodate the proxies as best you can. Again, we can use the electronic proxy or electronically transmitted proxy for obtaining a quorum in an HOA. Also using that proxy for the proxy to cast a ballot in the election of directors. So again, those are some comments. It's obviously a lot more detail in there. And I'd be happy to address those questions about elections that we might have there, Jeff, as well.
So let's see here. We have a couple in the queue, but as we promised, anybody who raises their hand has priority. So Adriana's back with a question about what you're mentioning now. Adriana, the mic has been activated.
Hi, okay, so I have an election that's going to take place beginning of January. I have 6 candidates for 3 positions, and they are already questioning how we're going to make sure the ballots are counted honestly. And it's going to be a Zoom meeting. So I was thinking 2 ways, and that's I wanted some guidance there. One is to put on the screen each ballot that is open so everybody can see, and they cannot say that ballots were created. And 2 would be if anyone has any questions, they can always request to see the ballots at a later date.
Well, first of all, Adriana, let me ask you a question. Is this a condominium or an HOA?
I'm sorry, it's a condominium, 16 units.
Okay. Well, the condominium process is pretty transparent. You'd go through the same exact process that you would with any election. You'd provide all 16 owners with their ballot envelope, return envelope. They then get that back to the association. Then when you're going to hold your election meeting, whether you have a quorum of president or not, then the election committee is going to take those ballots and validate the return envelope, make sure it has the proper name and unit number on it. Then after the meeting is convened, whether you have a quorum or not, doesn't matter. We're going to open the return envelope, remove the ballot envelope from the return envelope, and separate those out from the name and address, unit number. Then we're going to take those ballot envelopes, open those, and count the ballots. That would be the same way we would do it at any meeting. I would recommend using Zoom or some other platform that accommodates that, and have the camera where the people can see the person opening the envelopes, separating them, doing all that, or the people, maybe more than one person doing that.
It just facilitated, just like we're doing this now. I was on last night with a board in Broward County, and that's exactly what they did, Fred. They had one of the laptops was aimed at the counters, doing all of the work with the ballots. It was interesting. It was well done. It was well run. But pretty much what you're explaining now.
It's interesting to know. That's why I said for condominiums and cooperatives, this process is laid out for us. It's the same thing we would do at a membership meeting. If you've ever gone to the membership meeting where the ballots are going to be cast, first order of business is the election. And all the people are sitting there watching the people open the envelopes and count them and all that. We can do the same thing for those who want to attend Zoom. We're going to give them the same privilege as well. So that's how I would suggest doing that, Adriana, and maybe just like at a regular meeting.
Okay, yeah, the last year, the attorney was present and count the votes, and they're still challenged, so it's their prerogative, right?
I mean, I understand that there are concerns in many associations about the validity of the ballot, who matched the signatures and all that kind of stuff. I'm not sure that's necessary. If you're really concerned about your board, you might want your attorney to maybe participate by Zoom as well. You probably can pay their fees or hourly fees if they're going to participate, but that could be accommodated as well. I'm taking basically the same attitude for condominiums and cooperatives. I'm conducting the election just like I would at a real physical membership meeting, and just move forward from there. And if anyone wants to challenge that, I would say they can challenge the election process with the department, and they will move so as well. In HOAs, as I said earlier, it's more problematic. If you do have people that challenge the election process, then that goes to mandatory binding arbitration with the department. That can be costly, so you have to be very careful that you're complying with whatever your documents provide in the HOA world as well.
Thank you.
Again, my comments here or were prefaced by Jeff and ended by me here, anything you're going to do here that you think is going to be something based on statute or code, you want to get the stamp of approval from your association counsel. I know a lot of associations are reluctant to talk to legal counsel because there's money involved, but that's the best protection you can have for your board of directors and for management as well. And I know as managers, I'm always cautioning managers to remember, we don't tell the board what to do, we give them advice. And even though everything that I've said here today, manager may know, our advice is, this is what I think, but you need to talk to the association of counsel about this, make sure we're doing it right. If you don't do it right, there's repercussions for the association. There can be also repercussions for the board members individually, and we want to protect that as well. And as a manager, our job is, part of our job is to make sure we're providing the association with protection from the knowledge that we have as well. But all those, like I said, these questions I've gotten over and over again, so that's one of the reasons we decided to have this discussion. And if you have questions later or whatever, be happy to answer those now. If you have questions about anything other than what we just talked about, you're welcome to raise your hand or offer questions as well. I'll try to answer any questions I have in the remaining time we have. We allotted another 10 minutes here, so
Yeah.
Welcome to anything.
Right, there's a couple of them in the queue since there are no hands up, if that's okay.
Sure.
Cool. Anything further to add about the actual election, about having an election through virtual means? I know you covered it, but is there anything further just to, this is the question that we put off earlier.
Yep.
Anything further to add, or do you think that was fully addressed at this point?
The question that I have every time somebody asks me about election, I say, is it a condominium or cooperative or is it an HOA? If it's a condominium or cooperative, the process is laid out. And then you can do it virtually as well as you can do it in person.
Okay.
The bigger problem, the issue is in the HOA world where we don't have such guidance in the statute. There are some provision in there which basically says if you have an open nominating process, anybody that wants to be a candidate for the board can be a candidate. And then you don't have to have a nominating committee or that. Also, if you have that process in place, there are no nominations from the floor. So that takes that process out of the picture as well. I suggest today that HOAs, if anybody wants to be a candidate, even if you have documents, call for nominating committees. Those are somewhat obsolete in today's world. We're more than often than not scrambling to try to find somebody who's willing to serve on the board, try to get people to serve. But again, for HOAs, you've got to go back and examine your documents and the language in 720, I think it's 306, which deals with the election process for that as well.
Cool. And just swaying just real quick here, Amy, thank you for the kind words about this. This recording will be on the Gray Systems website once it's edited and uploaded, so that will be online. And tomorrow you will all receive a follow-up email thanking you for attending, and you'll have a copy of the slides. So thank you for that. Another question here. Can HOAs hold elections via US mail like COAs during the state of emergency?
Unfortunately, there are no provisions in the HOA statute addressing that. You could go back and use the board's emergency powers to say, we're going to do this under our emergency powers. There's no language in the board's emergency powers that says anything about elections. All it says is you can schedule or cancel and reschedule meetings, but it doesn't say anything about elections. It does give broad powers regarding the board's authority to do things, but most of what, it's a very lengthy section in each statute. It's basically identical in all three, but most everything beyond what I read earlier deals with handling damage after a hurricane. And so it really does not address an HOA using the mail-in balloting process. Now, again, I'm not advocating for the board to take extreme measures here, but as you know, there is no state agency that regulates HOAs. If the board decides to do it one way, if it's challenged, then it's going to go to arbitration. And if the arbitrator agrees with the challengers, then the election would be null and void, do it again. If the arbitrator agrees with the association and they had the power and the emergency powers to do so, then the election would be valid. That would be basically the end result. I would suggest trying to find some process whereby you could have the owners execute proxies and maybe use a limited proxy and putting on the limited proxy form for an HOA, listing the candidates and have them mark the ones they want to use and send that in. That's basically the same as balloting, but we're going to call it a limited proxy form. And I think the board has the power to, in the HOA world, to say, okay, we're going to provide you with a limited proxy. Now, recognize the board can provide whatever they want. An owner has the right to provide a proxy in the format they want to provide it in any case, HOA, condo, or go up as well. And I'm not sure that addressed the question, but those would be my comments with that.
Okay, well, thank you. Thank you. Our next one is, in a co-op, can a non-shareholder, like a trustee of a trust, for instance, serve on the board of directors?
And
welcome to this edition of Stump Fred.
now I'm trying to organize my thoughts. My initial answer is yes. Okay. There's a provision in the corporate statute that does allow the trustee, ownership trust situation, to serve on the board of a community association. I was going to reference the statute, and that's what I was trying to think of. I can't remember which one it is. If that person would like to email me at fgray@graysystems.com, I will send them that copy of the statute. And that was passed a number of years ago because we were seeing more and more units being held in trust situations. And there is a provision that allows the trustee to vote for the unit. I think it also allows them to serve on the board. But I want to clarify that before I answer that. But I know that I'm pretty sure that's the case. But if you email me, my email is fgray@graysystems.com. Or if you go to our website, graysystems.com, there's an ability to ask questions on there. You can ask that as well. I'd be happy to send you that reference from the corporate statute.
This is what it looks like in case some of you are new to Gray Systems. Here's the website that Fred just referred to, graysystems.com. And before I read the next couple of questions, we have a couple of folks asking, will Gray be conducting CAM CEU classes via Zoom? And the answer is yes, they'll be announced soon, right? The CE credits courses?
Yes. We are in the process in our office. It's interesting you ask that because normally our fall season, at the even number of years, we recoup and then we reschedule. And we scheduled out the year. We're in the process of doing that now. I anticipate this is the way we're going to do it in the future. I find this to be very desirable from my perspective. I didn't drive to Fort Lauderdale or Miami or Destin or Pensacola or anywhere this morning. You didn't drive anywhere to go to the program. We did Zoom classes this year. They were well received. I treat them just like the classroom. I anticipate doing this probably from now on. And we have that program that's going to be announced first week of January, the initial schedule, and it will accommodate as we always do, the required hours. We'll have the 3 hours of HRM, 3 hours of operation of physical property, 3 hours of finance and insurance, 3 hours of the elective. We'll have the 3-hour update seminars as well. We're actually 2 hours and 1 hour, but it'll be just like in the past, except it'll be Zoom. And hopefully you'll participate that way. We also have the distance learning is available, so all that be announced to you first week of January. Thank you for that.
Excellent, good information.
Yep.
Here's another question. It might be too specific, so if it's something that you feel would be for an attorney, just say so. But we have a 5-member condo board and have sent out our annual meeting and elections notice with the required 60 days. My question is, if we do not receive any intent to run forms in the next 40 days, does the existing 5-member board remain in place?
And I feel comfortable answering that because I've heard that asked enough by attorneys to answer. And here's the basic language. The corporate statute says a board member serves until replaced. If you have 5 board members sitting now, none of them submit a notice of intent to run. Okay. If nobody else submits a notice of intent to run, then the sitting board remains in place. Now, the problem comes if those people don't want to serve. What happens if they wake up on an election day and say, well, I quit? Well, what you want to do is keep at least one of them on there long enough to appoint 4 others to fill the vacancies, and then have that 4 others fill that 5th vacancy. So the answer is, the corporate statute anticipates that, and there's a process that follows there. And I feel comfortable answering that because I've heard that discussed so many times between the attorneys that it's pretty standard information as well.
No, that's cool. As long as everybody understands that this is not legal advice and this is educational, I think.
I think so.
Ready for the next one? Okay. This is with regards to an HOA. It looks like it's probably a Cam asking this question. So I have a board president who has been president for 10 years. Their bylaws provide for 2-year term limits and staggered terms. How do we approach her with regards to the absence of elections? She can be very obstinate and would likely fire us if we broach the subject with her.
The question, first of all, it's an HOA. As you know, the HOA statute does not address the limit on terms. Now, you have to go back and examine your documents to see if there's a term limit in your documents. A lot of the documents say that a board member may serve no more than 2 consecutive terms. Okay, but there is no limit on how many terms in the statute. They tried to address that in the condominium statute over the past several years, where they've now got it down to you can't serve more than 8 consecutive years unless you get 2/3 of the vote cast in the election process. There's no similar language in the HOA statute. So, absent any language in your documents, there's no limit on how long a board member can serve in an HOA. There's no limit on how long they can serve as a president of the HOA. If the board has confidence in that person to serve as president, and they continue to elect that person as president at each annual organizational meeting, then that person remains in office. There is a requirement, even if you don't have an election. If you don't have an election, you have an annual meeting, you still have an organizational meeting each year of the board for the purpose of selecting the officers of the corporation for the ensuing year. And the presumption is that the officers serve at the desire of the board, at the option of the board, and the board can at any time remove an officer from the board or replace him or vote somebody else in. So that's a problem. I recognize that. And sometimes we get that age-old person that wants to serve there forever. But I think the bigger problem is trying to find other people willing to replace them. I know in HOAs, there's quite often the lack of a participation in the HOA, where you have the people that just don't want to participate. And that's even more problematic for HOAs than it is for condos and co-ops as well.
Okay.
I don't know if that's a question, but try.
Yep.
Question.
Well, we're running close. Let's do 3 more questions, and then we'll let it. We know it's getting close to lunchtime. People getting antsy. We don't want anybody getting hangry. It's hungry and angry. We don't want that. So we'll do 3 more questions. Actually 4. No, the question. This is not a Hanukkah tree. This is a New York Mets tree. Somebody actually asked me that. Just missing some orange on there, but thanks for the question. And happy Hanukkah. I do celebrate that as well, by the way. All right, so in an HOA, can election ballots be counted prior to the annual meeting and the winner announced at the annual meeting?
Again, for an HOA, it depends on the language of the document. If the documents require balloting in the election of directors, there's nothing in the statute that presumes when that ballot will be counted. The bigger issue is what the documents provide. Do they actually provide for a ballot? That's something the board has instituted. But my answer is there's nothing that prohibits that. You need to make sure that to avoid any controversy, people think that maybe some wrongdoing that we've seen, say recently in our national elections, that you do it with transparency so that you can document that it was done by a nonpartisan board or whatever it might be, or nonpartisan group. And I would not have the board counting those. I would have some entity other than the board but responsible for doing that. But that, again, that only applies where your documents do provide for balloting. And that's unusual for an HOA as well. So Again, not prohibited.
Okay.
Next one.
All right, last two questions, and if they go unanswered, remember, Fred will get a copy of all of the questions and we'll answer you via email. So we're just going to do two more because we're running close to the end of the time here. This may be an attorney question. Let's see, Fred. HOA and vacation rental community. Okay, HOA and vacation rentals. What is our responsibility to inform guests and owners when a board member or an owner tests positive for COVID? We recently had to close down due to a board member contracting it.
I'm not going to answer this as an attorney. I'm going to answer this as what I've heard from attorneys and from others as well. The association has an obligation to acknowledge that there has been a COVID event. You would never identify the person or the unit. Okay, but we do acknowledge that there's been an event in the community, and that gives everybody the knowledge that they have if they want to go to be tested or to not use the community, whatever it might be. So from what I've heard, it's acknowledging it, but not identifying. Okay? And be very careful about that as well. You don't do anything to give an indication of who or where it might have been.
Right.
It's funny, I heard that in another roundtable discussion that was with the attorneys. And they were all basically in concert with that as well, in agreement. We're crossing that line with the HIPAA requirements and
right.
All that kind of stuff, privacy. So be very careful with that.
Right. Definitely ask your counsel if you're not sure. Here's another nice question here from Tony. First, thank you Fred for putting this together. And yes, thank you. This has been great, Fred. Thank you. My question is, will the DBPR, do you think they'll have any alterations to the required continuing education requirements coming up? I know they made some alterations last July. Do you think there'll be any more coming up?
The last, as far as the community association manager continuing education requirements, for those of us been around for a long time, when the Regulatory Council was created back in the mid-90s, they increased the requirement from 14 hours to 20 hours at that time, or 16 hours to 20 hours. Right. It's been 20 hours until last year, 2019, under direction from the fairly new Governor DeSantis. The council reduced the requirement from 20 hours to 15 hours. I don't see that number changing anytime in the future. The bigger question, and the question that I keep presenting to the council, is some latitude in the subjects. We've been doing the same subjects for 25 years now, 30 years now, and we're kind of limited as a provider with what we can do. That's what I mentioned earlier. We have the 4 hours of operation of physical property, 3 hours now, 3 hours of HRM, 3 hours of finance and insurance, 3 hours of elective, 3 hours of legal update seminars. I would like them to give us those topics and let us divide courses that fit in there, which we can make more direct and I think more, meaningful for the managers and spend more time on different topics. But that discussion has been going on between us and other providers and the council now for 15 years, so I don't know where we're going to get with that as well. We also have a problem with the council because quite often they don't have a quorum, and even appointees on the resorts as well. And by the way, any changes have to be approved by the Regulatory Council of Community Association Managers. So that's where that requirement comes from. But I appreciate that question because we're constantly evolving in that as well. I know those of us that have been in class with us over the years, I've always commented on that. I would like a lot more latitude in what we do, but we don't have that flexibility right now.
Okay. And we had somebody raise their hand. Do you have time for one more?
Sure.
Even though we said,
okay. I'm here. Good.
Diane?
Yes, Fred. In recent years, the HOA laws have become more in tune with condo laws. I haven't seen any pre-filed bills yet this year that are changing the HOA laws. Are you aware of anything that's going to bring the HOAs more in line with condo?
The question relates to expanding the HOA regulatory statute, Chapter 720, to be more in line with the condominium cooperative requirements. The answer to that is no. About 6 years ago, there was a proposal to basically move the HOA regulation under the Division of Florida Condominiums, Timeshares, and Mobile Homes, provide basically the same regulation, obviously with accommodations for the difference between the ownership of an HOA and the condo cooperative world as well. That was bounced around for 3 sessions. It came up in 3 sessions of the legislature, and basically it never got anywhere in the legislature. There's too much opposition from the legal world, the banking world, the real estate world, and the developers world to increasing the regulation for HOAs. So I don't see anything like that happening, Diane. I think the more likely scenario is somewhere down the road, probably not in our business lifetime, there will basically generate one law that becomes the community association law, and then set up separate laws for the developer obligations for condominium, co-op, and HOA. And that's much more likely than that. So I don't know if you're an advocate of regulation for HOAs or not, but I don't see that happening anytime soon. Could be wrong, but don't see it happening.
Thank you.
Right, you're welcome. It's a good question. Jeff, you're muted. One more.
Muted. The last question is okay. This will be the last one, and then we're going to let everybody get some lunch. So the last question of the day is: I have a board member in a COA that has served 12 years. No one will volunteer when the notices go out. Does the 8-year apply? She is elected every year. Might be a little too specific, but
that's a very good question. And I go back to what I have said earlier. The condominium statute provides that if you don't have anybody willing to serve, then the people who are on the board continue to serve. So if you don't have anybody submit notices that they want to serve on the board, then that person would continue to serve. The way the law is written with regard to term limits, it says a board member cannot serve more than 8 consecutive years unless they're approved by 2/3 of those voting in the election for that year, or unless nobody else wants to serve. So that would answer that question. They can continue to serve. I can't imagine why anybody would want to serve more than 1 year, but they can. So,
maybe they're still smiling at the end of the first year and they don't mind joining you.
No, I mentioned that. There are some very dedicated board members out there. We really appreciate that as well. And unfortunately, we do have a lot of associations out there that can't find people willing to run for the board.
Right. And
then it seems like somebody's dominating, but it's not really because they want to dominate. They're just doing it because somebody's got to do it, and they're willing to do it. And sometimes people don't agree with them. And I've always said, if you don't agree with them, run for the board. But anyway, that's
right. You can do it too. And well, that wraps up all of the questions. Oh, one more question popped up, but this is more of an administrative question. Are there 2 legal updates each year? I'm still a bit confused by when to be looking for an update each year. And I think the answer to that one is that, like, for instance, now the legal update 2021 is out and it covers the new legislation from 2020. And I think when people see, and Fred, correct me if I'm wrong, when people see all these different advertisements for legal update classes, it's usually because an organization didn't update their legal update course to cover the newly required 3 credits instead of 2 credits, but you've done that. So when somebody takes legal with Gray, it's a one-shot deal and it's all done, correct?
Yeah. Right now, the legal update requirement is 3 hours.
Right.
When that first came out in 2019, I approached the Regulatory Council staff about getting a 1.5 hour course approved. And they came back and said, we don't
half an hour
courses. And so I did a 2-hour course for 2019 and a 1-hour course for 2020. And I couldn't fill up the time there as well. The 2021 update that I have, I'm having it approved in both versions, 1 hour and 2 hours.
Cool.
Then I'm going to do the same thing for the 2022 update when we get that information as well. It's important to remember that the quote update seminar covers stuff that was passed last year in 2020.
Right.
And one of the things that I have done, and I never asked Marcus if this was okay, but I'm doing it anyway. as soon as we get legislation,
For those who don't know, who's Marcus?
but as soon as we get legislation in 2021, I'm going to incorporate that legislation in whatever updates we're doing for that year as well, and become more current with that information as well. So right now, it's a 3-hour requirement. You can take it in a 2-hour chunk or a 1-hour chunk. And so that's your option, but it will be out there as well.
Excellent.
We're asking that as
Excellent.
well.
Well, Fred, this has been fantastic. We've had some great comments on here, some fantastic questions, lots of compliments. We appreciate them. I assure you, Fred will get all of your comments, and after this event, I'll receive everything you've said. We appreciate that. And I do want to mention before Fred gives his final few words here, tomorrow, all of our attendees will receive an email with a short, brief evaluation. You'll also have an opportunity to download those couple of slides on there. And in this evaluation that you'll get tomorrow morning, there'll be a space on there for topics you'd like to see discussed with future roundtable discussions here. So please fill that portion in. If you don't fill any other portions in, please fill that portion in. Give us some of the stuff you'd like for Fred to cover in future editions. And I think we also have another one scheduled to be announced soon in January, Fred, with somebody very big in the condo world that would like to elaborate.
Yes, well, as Jeff said, we plan on continuing this roundtable discussion. We're excited about it. I like it because I can bring things that I've been discussing with managers at the table, the ones that I pick up on most. We scheduled, I think it's January 21st, a roundtable, and our guest is going to be the condominium ombudsman.
21st.
Ombudsman, and Spencer Hemmings, but he's very enthusiastic. We're excited about having him. If you're involved in the condominium world, you want to participate in that. And he's taking a whole new approach to the ombudsman's duties, responsibilities, and priorities as well. So we'll have that. You'll get announcements about that. And I want to say for myself and our organization, we greatly appreciate all of your participation. Hopefully look at this and use our educational services as well. But I'd like to remind, I've done this for years, even after the class is over, after the program's over, I'm available to you, email, phone call. I don't recommend texting me. I'm still not 100% yet, but I do.
A small screen is so difficult sometimes too.
It's big fingers. You know. I can't hit the microphone button either, but welcome to contact us any way you want to. We're here to try to help you with anything we can and hopefully satisfy your educational needs as well. And I want to say thank you very much. Thank you, Jeff. Have a great day and have a great holidays, and we'll see you in January, I hope. Thank you.
Thanks, everybody. Happy New Year. And this will be on the website once we have it downloaded and edited too, so you can watch it once again if you want to. Happy holidays, everybody. Happy New Year. Merry Christmas. Happy Hanukkah. Just be safe, healthy, and stay safe out there.